Ever wondered what happens when a country, fresh from monumental change, boldly redefines justice and reshapes how its gravest crimes are dealt with? It's not just one big announcement, is it?
No, absolutely not. It's a deep, intricate process. Legal, moral, societal.
Exactly. And today we're tracing that powerful journey through South Africa's Criminal Law Amendment Act 105 of 1997.
A really pivotal piece of legislation.
Right. This isn't just some dry legal document. It feels like a living testament to a nation's commitment to new constitutional values.
And its ongoing fight against serious crime. It's evolved a lot.
Exactly. This act is a truly landmark piece of legislation.
It really is. It reflects a profound constitutional pivot, not only in formally abolishing the death penalty.
Which was huge in itself.
Huge. But also in introducing a structured yet flexible approach to minimum sentencing for a whole range of serious offenses.
Setting a new foundation, really.
Yeah, laying down how justice would be conceived and administered in post-apartheid South Africa.
So, our mission today for this deep dive is to explain this consolidated act, make it clear and engaging for, everyone. The general public, maybe aspiring legal minds too.
Right.
We'll outline its core purpose, its key provisions, the legal context that shaped it, practical implications, real-world significance.
And it's important to see it as dynamic.
Definitely. We're looking at it as a living, breathing document. Updated, May 2024, reviewed March 2025.
That's right. The consolidated version shows its journey.
And that consolidated act itself is our primary source, letting us track it from 97 through all the amendments.
Okay, let's unpack this journey then.
Yeah. Imagine South Africa, mid-90s, emerging from decades of profound change.
A completely new constitutional era.
Establishing a new constitution, enshrining fundamental human rights for everyone, and central to that was the right to life.
Absolutely paramount. The whole legal system had to align with this new moral and constitutional compass.
And the Act reflects that directly.
Indeed. The Act's preamble, its introduction, is remarkably clear. It directly references the 1996 Constitution.
Which guarantees the right to life.
Explicitly. And crucially, it notes the Constitutional Court had already ruled the death sentence unconstitutional and invalid.
So the court ruling came first.
Yes. So this act wasn't just a policy choice. It was the legislative response, a legal and moral imperative to align criminal law with that foundational order.
That makes sense. It establishes the fundamental why behind it all.
Exactly. Shifting the state's power away from taking a life.
So once this constitutional shift happened and the court ruled, what did it mean for those individuals already on death row?
Yes. A critical question.
I mean, it's one thing to declare it unconstitutional, but managing those existing cases, that must have required care.
And that's where Section 1 of the Act comes in. Substitution of sentence of death. It's incredibly meticulous.
Right.
The Minister of Justice was tasked, as soon as practicable, with referring every death sentence case where appeals were exhausted back to the original sentencing court.
Back to the original court.
Yes, constituted by the original judge if available, or another designated judge.
And what did that court do?
It would consider written arguments from both the person sentenced and the prosecution.
Yeah.
They could even hear oral arguments if needed.
So it wasn't just an automatic conversion of sentences, like death sentence becomes life imprisonment, done.
Absolutely not. No blanket conversion. The court's role was very specific: to advise the president with full reasons.
Advise.
Yes, advise on an appropriate substitute sentence, maybe a term of imprisonment, and potentially an antedating date.
Antedate, that's backdating the start of the new sentence.
Essentially, yes. Often back to when the original death sentence was imposed. The president then formally set aside the death sentence and substituted the punishment the court advised.
And could that advice be appealed?
That's a fascinating detail in Section 1.5. No appeal could be made regarding the court's advice itself. It highlighted the weight of that review. And the Act provided for legal aid, ensured representation, and directed the Supreme Court of Appeal on handling pending appeals, always setting aside the death sentence.
The level of detail in that transition, it's really something.
It is. It signified a profound assertion of individual dignity and the right to life, even for those convicted of the worst crimes.
Reshaping the state's power fundamentally.
A radical shift, yes.
That meticulous process for individuals really highlights the commitment. But as you said, the Act's impact went much further. It sounds like a complete overhaul of the legal codes.
It really was.
How did it manage that kind of harmonization across the board? It wasn't just patching holes, was it?
No, definitely not rebuilding from the ground up. That's where sections 25 through 50 are key. They detail extensive amendments and repeals across a wide range of existing laws.
Aimed at what?
Systematically removing all provisions related to capital punishment. For instance, it repealed key sections of the Criminal Procedure Act 51 of 1977.
The main law for criminal proceedings.
Exactly. Sections like 277, 278, 279, which dealt directly with the death penalty, gone. This wasn't cosmetic. It fundamentally altered sentencing structures.
A truly systemic overhaul, then, making sure every corner reflected the new values.
Comprehensive. And it went even further. You need to look at Schedule 1.
Schedule 1, what's that?
It provides a detailed list of laws from various former homelands and territories, Transkei, Bophuthatswana, Venda, and others that were also amended.
Ah, so ensuring consistency across the entire country.
Precisely. It shows the massive effort to consolidate and harmonize the legal framework nationwide under the new constitutional principles, a unified approach to justice.
Creating one coherent legal identity.
That was the goal, leaving no room for outdated, unconstitutional provisions.
Okay, so after dealing with the past, sweeping away the old framework, the Act looked to the future.
Right.
And this is where it gets really interesting for a current criminal law, establishing minimum sentences.
This brings us to Section 51. Discretionary minimum sentences for certain serious offenses.
Okay, what was the purpose there?
The aim was clear. Ensure severe consequences for grave crimes, provide a baseline punishment, but still allow judicial discretion in specific, defined circumstances.
A baseline, but with flexibility.
Exactly. The core structure is a tiered system in Schedule 2. It applies to regional and high courts, the main courts for serious crimes.
And the sentence depends on?
Two main things. The seriousness of the offense, categorized in parts I through V, and crucially, whether the offender is a first, second, or third, or subsequent offender.
Can you give us some examples? How do those tiers actually work? What kind of time are we talking about?
Certainly. For Part 01 offenses, the minimum is life imprisonment, straight up.
Okay.
Part 2, first offender, not less than 15 years, second offender, 20 years, third or subsequent, 25 years.
Quite a jump for repeat offenders.
Yes. Part 3, 10 years for a first offender, 15 for a second, 20 for a third or subsequent.
Okay.
Part 4 offenses, minimums of 5, 7, and 10 years respectively. And Part 5 starts at 3 years, then 5, then 7 years for third or subsequent offenders.
That tiered approach really must have changed sentencing practices, made them more predictable.
More predictable, yes, but still allowing for flexibility. That's key.
Right, because it's called discretionary minimums. What's
Yeah.
the discretionary part? Can a judge just ignore these if they feel like it?
No, not at all. That's the crucial balance. A court must impose the minimum unless it's satisfied that substantial and compelling circumstances exist which justify the imposition of a lesser sentence.
Substantial and compelling. That sounds like a high bar.
It is. It's not just the judge's preference. It has to be a truly exceptional situation, rigorously justified, and crucially entered into the court record.
For transparency.
Exactly.
Yeah.
Ensuring the minimums aren't easily sidestepped.
So it allows for those really extreme or unusual cases where the minimum might just be unjust.
That's the idea. But there are also specific exclusions, right? Especially for rape cases.
Yes, precisely. A very powerful move for victim protection in Section 51(3)AA.
What does that say?
It explicitly states that for rape cases, certain factors are not to be considered substantial and compelling circumstances. Things like
Like what?
the complainant's previous sexual history, an apparent lack of physical injury, the accused's cultural or religious beliefs about rape, or any prior relationship between them.
That's significant. Actively combating harmful stereotypes.
Definitely. And other important bits. Minimum sentences can't be suspended, right?
Correct. Section 51(5), no putting them on hold.
And it doesn't apply to minors.
Right. Accused persons under 18 at the time of the offense are excluded, and the state has to prove their age if disputed. The Act also defines law enforcement officer, which matters for certain offenses in Schedule 2.
Okay, which brings us to the big question. How do we define those serious offenses? What crimes actually fall into these parts 1 to V?
Well, that's what Schedule 2 does. It's the practical guide. It lists the specific offenses that trigger these minimums.
Giving us a clear picture of what the legislature considered most serious.
Exactly. And it's a list that has evolved over time.
Okay, let's look at some examples. Part Ham, life imprisonment. These must be the absolute greatest.
They are. For Part 1, we're talking about the most heinous crimes. Murder, for instance.
But not all murder.
No, specifically murder if it was planned or premeditated, or if the victim was a law enforcement officer, a witness, or a child under 18.
Okay.
Also murder committed during a rape or aggravated robbery, or by a group acting in common purpose.
Common purpose meaning?
Sharing the intention to commit the crime, even if not everyone does the same specific act. Also in Part 1, trafficking in persons. Certain serious terrorist activities.
And you mentioned upcoming changes.
Yes. Important to note, uncommenced amendments already outline how hate crime elements for murder or rape would also fall under Part 1. Shows the law adapting.
Okay, moving to Part 2. Still incredibly serious, but minimums of 15, 20, 25 years. What's in here?
Right. Here you find murder in circumstances not covered by Part 1. Also, serious robbery, aggravated robbery, or involving a vehicle hijacking. Significant drug dealing based on value, like over $50,000, or smaller amounts if it involves common purpose or a law enforcement officer.
Financial crimes, too.
Yes, large-scale ones. Fraud, corruption, theft over certain high thresholds, again with higher stakes of law enforcement or common purposes involved.
And infrastructure theft, that's become a big issue.
A very big issue. Theft of essential infrastructure, metal, copper cables, railway lines if it causes disruption or damage or involves insiders, falls into Part 2.
Cybercrime.
Certain serious cybercrimes, too, with similar financial thresholds or involvement of insiders law enforcement. And significantly, rape or compelled rape in circumstances other than those specific ones listed in Part 1.
Okay, so that covers a lot of ground. What about Part 3, the 10, 15, 20-year minimums?
Yes, these often focus on crimes against vulnerable people or public safety issues, like assault with intent to do grievous bodily harm on a child.
Specific definitions there.
Yes, under 16, or 16, 17, if there's a significant age gap with the accused, or if it's domestic violence related. Also, possessing more than 1,000 rounds of certain ammunition.
Reflecting concerns about firearms and crime.
Exactly.
And finally, Parts 4 and V, lower minimums, but still significant.
Yeah. These round out the picture, reflecting proportionality. Part 4 includes things like treason, sedition, kidnapping, certain assaults with dangerous wounds, especially if a firearm was involved.
If not already covered higher up.
Correct. Also things like breaking and entering premises to commit an offense, or escaping custody, often if a firearm was present.
And Part 5.
This covers offenses like certain types of essential infrastructure theft that don't meet the severity criteria for Part 2. It's about having a nuanced, tiered response.
A systematic approach across a broad spectrum of harms.
That's the aim.
What a journey through this act, the Criminal Law Amendment Act 105 of 1997. We've seen its dual impact.
Transformative, really.
Definitively ending the death penalty and ushering in this whole new era of minimum sentencing.
Reflecting that new constitutional reality.
And connecting this to the bigger picture.
Yeah.
As you said, it's not static.
Not at all. We've seen numerous amendments, updated recently, reviewed recently. It keeps evolving.
Why? What drives the changes?
Ongoing efforts to strengthen justice, adapt to new crime types like cybercrime, integrate evolving constitutional protections, like those potential hate crime provisions.
So it really is a dynamic, living document.
Right at the heart of South African criminal law, constantly adapting to the nation's values and challenges.
So what does this all mean for you, the listener, whether you're in law, studying it, or just interested?
Understanding this act reveals that intricate balance
between punishment, rehabilitation, fundamental rights. It's all there.
A powerful example of how a nation's laws reflect its deepest values.
So given this evolution, abolishing capital punishment, building this minimum sentence framework, more amendments coming, how might legal frameworks like this keep adapting?
That's the ongoing question.
Balancing constitutional rights, victim protection, new crime types in this rapidly changing world. And maybe a final thought for you to consider. What role do you think public opinion or maybe new technologies might play in shaping future amendments to foundational criminal laws like this one?